I'm going to talk about the CISG from the common lawyer's point of view. And the first thing I want to say at the outset is thank you to the Law Foundation New Zealand for allowing me to come to breezy Wellington. So, not quite as windy Wellington I've heard about before. My focus is essentially on two things. The first is the general features of the CISG as they appear to a common lawyer. The second is substantive features of the CISG as they are not necessarily apparent in an instrument like the Sale of Goods Act of 1908. And I guess my essential point, above all, giving the Sleeping Beauty theme that's attaching to this particular message, and we can thank Petra Butler for that, is that it may be worth going through the forest of thorns to embrace Prince Charming, or perhaps in this enlightened age, Princess Charming, at the end of the journey. So now, let me take a look at the general features of the CISG. First of all, it purports to be a code. Now, it's like being in an enclosed room. The answer essentially is to be found within the enclosed room. There is, however, a small window of opportunity, which I'll come to in a couple of minutes, but essentially you have to find the answers within the room you're in, because you are not surrounded by congeners, as it were. There is not an extension of the CISG available for dealing with contiguous issues such as tort liability, agency, and related matters. It is a sales statute, if you like, though it is one with a rather broad range, because the CISG, as expressed in Article 4, applies to all the rights and duties of buyer and seller, with the exception of validity, with the exception also, though this is not a matter of right and obligation as such, the passing of property between seller and buyer. So a civil lawyer, and I would suggest also a common lawyer too, would be very wise to read that general statement in Article 4 with the breadth that it provides, all the rights and duties of buyer and seller. Now, it's well known that the Sale of Goods Act has a very substantial escape provision, if I can call it that. The common law, even the law merchant, and the rules of equity apply so far as they're not inconsistent with the Act. So to say that the Sale of Goods Act is a codification is very far from saying that it's a code. And that's something to be appreciated right at the outset. My next general observation is this. Article 7.1 deals with the interpretation of the Convention, and it is a provision of considerable importance. It requires courts and tribunals to apply the CISG in an internationalist spirit. It requires them also to bear in mind the exigencies of good faith and international trade. Now, that's a duty resting on courts and tribunals. It's not a duty resting on the parties under the contract of sale. And the full implications of this have never really quite been considered. I think, for my part, the essential question is, insofar as the court applies the provision of the Convention, how much degree of ambiguity has to be present in the particular provision before it can introduce this notion of good faith? Can it, for example, fly in the face of a clear provision in the CISG if it thinks this is appropriate for good faith purposes? That has not really been resolved at all. But the CISG, as a convention with now 78 states and more to come, is not something that can readily be amended from time to time. And this is where case law comes in. And we know there are more than 3,000 cases, and very, very many of these are translated into English. There is a very large bank of decisions out there, and we may or may not be seeing the development of something rather like an informal doctrine of precedent. The question that has not really reared its ugly head is whether a single decision of the German Bundesgerichtshof trumps three decisions of the Hofbank of Rotterdam, for example. But maybe that kind of thought is beginning to develop in the secondary literature. Interpretation. Article 7.2, this is where we come to the full implications of the code. It's all about filling gaps. Now you have in this, this little book, the Hong Kong version is red, and it can be brandished in that part of the world with rather terrifying effect, I understand, as it reminds various people of what happens to their parents or grandparents in the time of the Cultural Revolution. But Article 7.2, about the filling of gaps, exhorts the court or tribunal to define the coverage of the CISG, remember it's broad, and to define from the provisions of the CISG as a whole a general principle that can be applied to resolve a matter that is not explicitly dealt with in the 88 non-diplomatic provision articles of the CISG. 88 provisions dealing with introduction of general principles, formation, and the substantive duties and remedies between seller and buyer. And by, as it were, drawing from particular provisions, one can perhaps identify principles such as the principle of estoppel, the principle of maintaining the existence of the contract as far as one can. Fundamental breach makes it very difficult to avoid a contract, and one can see there some intention on the part of the convention makers that so far as is possible, the kind of heavy costs involved in unwinding an international contract should be avoided. The principle of party autonomy and freedom of contract is writ very large within the CISG, and that is something that should be encouraging to common lawyers. And it's not just, as it were, drawing general principles from specific provisions. It's taking a provision and saying, well, there's no reason why this provision should not be extended a little bit. So, for example, there are rules dealing with simultaneous restitution of goods and price if a contract is unwound in the event of avoidance, but nothing that quite says so explicitly when it comes to restitution of interest on the purchase price and restitution of benefits afforded by the goods. And yet it makes perfect sense to extend the principle of concurrency into this field of what you might call secondary restitution. I referred before to a small window. The court that cannot find the general principle can leap through that small window into the world of choice of law and go to the applicable law. And the applicable law is important too when it comes to that exception of validity that I referred to before. Validity, by the way, as an expression used within the CISG, is a concept that has an autonomous meaning within the CISG. And actually working out the implications of that and defining what it means by reference to different national legal systems is a challenge that is going to absorb quite a lot of energies in the decades to come. I've covered a few general principles. I'm conscious of time. I'll say a couple of things about interpreting the contract. Lord Hoffman, in a case called Chartbrook, said that the CISG demonstrated the French subjective approach to contractual interpretation, at which point, no doubt, the readership in the United Kingdom reeled back in horror. But if you actually read Article 8, which deals with interpretation, it says in the first instance, subjectivity prevails as long as the other party knows or could not have been unaware. Well, now, that doesn't seem to me to be a resounding statement of subjectivity. So then you fall back on the secondary rule. The second rule says, if you can't work it out subjectively, then it's what the reasonable co-contractant understands. So at this point I say, why should the common lawyer be afraid of what the CISG is saying? It's essentially an objective rule dressed up as a polite compromise between two great legal traditions. Subsequent conduct. Well, I think New Zealand, if I recall, has given way on the old common law approach that you should not interpret a contract in the light of subsequent conduct. I've no doubt myself that subsequent conduct can be looked at, and it says so in the CISG, in interpreting a contract. to my mind, much of the debate in the common law is really about something that we might call a false problem now, and it's about the doctrine of consideration. The CISG, clearly but not in so many words, excludes the common law doctrine of consideration, especially from modification of contracts, in the same way as it excludes the civilian doctrine of cause in the formation of contracts. And to the extent that consideration has gone out of the window, then there's no reason why you can't, from the common law point of view, look at conduct as modification of the contract. It's as easily done as using that conduct to interpret the contract as it was originally defined. And it's actually a rather more honest way of working out the intention of the parties. Enough of that. I've already referred to validity, and I will perhaps now dip into a couple of features of the substantive text. I think my basic message here is when we come to formation, and I'll abbreviate this very much, the features that might surprise a common lawyer in New Zealand and England are maybe not so much civilian, 5 minutes, they're more Article 2 of the Uniform Commercial Code. Or perhaps in one case, a combination of Article 2 of the Uniform Commercial Code and the civil law. So, for example, there's a rule on firm offers in Article 16, paragraph 2, which is capable of giving rise, I think, to problems from a common law's point of view, and yet has rendered surprisingly few cases. So I'll say no more about that. There is also a provision beloved of the American architects of Article 2 about contracts formed by the mirror image of offer and acceptance, where there may be very minor additional terms in the acceptance, and yet it will still function as an acceptance unless objected to. But by the time you work out what a very minor feature is, you find that there can't be anything that really qualifies as a very minor feature, because all of the major features have been identified, and they cover the whole ground, more or less. So I say no more about that. Fundamental breach. Well, we've been told that the doctrine of conditions and warranties has disappeared, and that fundamental breach is basically based on the notion that the buyer can't make any use of the goods. Well, I would say, by way of cautionary observation, that's what the German courts say. And one of my problems, perhaps, with the way certain courts have treated the CISG is that they have seen in the literal text something that isn't there. So Article 25, fundamental breach, says there has to be a substantial failure of the benefit contracted for. Now, that's not quite the same thing as saying the goods have got to be of no use to the buyer, or avoidance of fundamental breach is an ultima ratio, a last resort, a last-ditch expedient. And even as the German courts have said that, in one or two cases they've said, but certain provisions in, for example, CIF contracts are clearly of the essence so that any breach will justify avoidance. Well, again, Article 25 doesn't say that. It is a fact-based test that looks to the actual consequences of a breach in a particular case. So there's going to be some tugging, pushing and pulling amongst the various national courts as the various provisions of the CISG are interpreted in the years to come. One or two features within my very limited time. One is the doctrine of cure of defective performance, which is a very clear US provenance. Its major purpose in the US system is to prevent surprise rejection of the goods, and it works against the background of a tough perfect tender rule. Well, it's the classic example of a legal transplant that's gone wrong. There is no tough legal tender rule in the CISG, and so you have a provision of uncertain scope which does little more than back up the doctrine of mitigation of damages. Specific performance. Well, Pascal has spoken to that. I would say, of course, there's no hierarchy, but how many people in international trade want specific performance? You'll probably find that the cases where they need it or want it are cases that correspond to the exceptional approach to specific performance, that it's there and available when damages would not be an adequate remedy. Another transplant from the Uniform Commercial Code. There has been introduced a right of suspension, but here's where the transplant comes in. The other party can lift the suspension by providing adequate assurance of performance. Now, when I've looked at Article 2 of the Uniform Commercial Code, I've never worked out what adequate assurance there of due performance actually means. Does it mean I really, really do intend to perform, or does it mean I have a bank behind me with a performance bond, or does it mean something in between? Well, again, the answers are not there in the UN Sales Convention, and that one is waiting to be developed. Two last points before the conclusion and before the man with the umbrella pulls me off the stage. That's a reason, by the way, why I'm not standing up and I'm sitting down. I've got a lower centre of gravity. There is a civil law remedy in the Convention that may not be understandable necessarily to all common lawyers, the remedy of price reduction. It's like the buyer's unilateral right to revise the contract and insert a different price. It would be, I think, a remedy with significant ramifications in England, because we've taken the view in recent years, wrongly I think, that if the buyer cannot demonstrate a loss, and yet the goods are quite severely defective, the buyer gets no damages. Now, that particular problem of proving loss disappears when you come to price reduction. And the buyer, under the CISG, has a choice between going for damages or going for price reduction. It's the old Roman law actio quanti minoris, the reduction of the price action. Avoidance and restitution implications. It's tough to avoid a contract under the CISG, but the right lasts a lot longer, and it survives notwithstanding an inability to make full restoration of the goods. That generates considerable restitutionary complications because you have the return of the initial prestations, price of goods, but also the seller is deemed to earn interest on the price, and the buyer must account for benefits derived from the goods. Now, how you work out benefits derived from the goods when you have the buyer's own contribution to the goods, overhead, fixed and floating, well, that's anybody's guess, and we haven't yet got there in the case. So what does it all come down to in the end? A and B. The CISG is a treaty. It's a convention, and it mustn't be read in the way that you would read a statute of the Westminster Draftsman. Secondly, there isn't a great deal of civil law to shock in this convention. If I had to form a view and say civil law, common law, I'd be more inclined to say there's more common law here, but much of that has been filtered through Article 2 of the Uniform Commercial Code, because the Americans, when they get to Vienna and to New York, when Austria is sitting, are very persuasive and very well organized. They operate like a wrestling tag team.